You have recently retired from the Tennessee Supreme Court. So you have served on 3 levels of Tennessee courts. How did you happen to go on to the Supreme Court of the state of Tennessee?
Well, Lyle Reed retired in March of 1998, and of course that left a vacancy that needed to be filled, and I thought, well, I might as well apply for it, and so got nothing to lose, and I applied to it was then called the Judicial Selection Commission, and I was one of the 3 folks that they recommended to the governor, and Governor Sundquist again appointed me, so he appointed me to both courts, to the Court of Criminal Appeals and to the Supreme Court, and I was sworn in by him on, actually Riley Anderson administered the oath. He was our chief then. That was on April the 8th of 1998. No, April 23rd, 1998, somewhere in April.
What was the most noticeable difference you experienced when you were a member of the Supreme Court as an associate justice after your earlier judicial experience?
Most notable difference is, you know, on the Court of Criminal Appeals, Rule 3 of the Rules of Appellate Procedure give everyone a right to appeal as of right. And on the Supreme Court, it's mostly Rule 11 appeals, which means you get an appeal by the grant of permission. I don't know why we don't call it a writ of certiorari, but they call it an application for permission to appeal. So they only grant a relatively few number of cases for specific reasons, perhaps just to clarify some rule of law that hasn't been clarified, to develop the law. So it's something that's a fairly important issue, and because of that, we don't take that many cases, and we spend a lot more time and a lot more care in preparing our decisions, because the Supreme Court of Tennessee is the final court on the say of what the rule of law is in Tennessee. And we spend a lot of time discussing which cases to grant permission to appeal in. You know, the lawyer might get a 1-sentence order back upon due consideration. The application for permission to appeal is denied. And they've spent a lot of time and a lot of work trying to get it ready, and they said, well, they didn't even look at it. But we may have looked at that case for 2 or 3 months and had a lot of discussion about it before we find. So each case, a lot of discussion went in, a lot of preparation went in, and I loved doing that.
What's the process for winnowing the cases so that you just, before you decide to take a case?
Well, we would, you know, there's a rule, and I forget which one it is now, that sort of outlines our criteria for granting permission to appeal. But in general, it has to be a case that has a relative degree of importance, beyond just the importance it has to the 2 litigants, but to the population of the state as a whole. It may be that one section of the Court of Appeals has reached a different conclusion than another section on a similar or the same issue. It may be on some question that we think we need to write on because we've never decided the issue before. It may be because we want to develop the law further than it has been before. It may be because we want to announce that we don't want to develop the law any further than we did before. But it has to be a decision that is going to make a difference.
Do you remember the first experience you had listening to arguments and preparing for those, to hear those arguments?
I don't remember the first one, but I certainly remember. I remember what we would do.
What would you do?
The Supreme Court is a hot court. And when I say hot, I mean we've all familiarized ourselves with the case, and we know what the issues are. And you don't have to come into court and inform us about what the case is about. We know what it's about. We've all read the applications for permission to appeal. We've had our staff attorneys prepare a memorandum. We've researched the case. So when we come into the courtroom, we pretty well know what the issues are and what we would need to ask. And it was really interesting to have those great discussions with some of the lawyers that would teach. You know, some judges say oral argument really doesn't change my mind. Well, that wasn't true for me. I've had my mind changed any number of times during oral argument. So I would recommend to all lawyers never waive oral argument. If a case is worth appealing, it's worth arguing.
before you went on the bench to actually hear argument, how would you prepare yourself?
Well, number one, I would read the application for permission to appeal. We had 8 staff attorneys, all located in Nashville. Some of them were experts, and I say experts, were knowledgeable more so than others in the areas of civil law, some in criminal law. And each one would be assigned to write a memorandum. And when we would look at the memorandum, we might ask them to write something else. We would do our own independent. I guess each of us would go about it in a different way, but my way would be I would look at the memorandum that had come in along with the application for permission to appeal. I might ask my law clerks at home to do a little research on an issue, and I might even, probably not often, but I might even go back and start reading the transcript, but probably would not read the transcript unless I needed to after argument. You just can't do it all before argument.
Would you go in to hear argument sometimes with a list of specific questions you wanted the lawyer to address?
Yes. I might not write them down, but I'd have them in my mind. And it was interesting because you could listen to your colleagues on the court, and sometimes they would ask questions exactly of what you had in mind, and sometimes they would ask questions you hadn't even thought about. And sometimes it would be interesting because you would get into a banter with another member of the court by the questions you were asking. You would ask a question, and somebody, but if you don't like that, and you could see there was a banter going on with the lawyer being the interpreter between the judges.
How many law clerks did you have?
Had 2.
How did you use them?
I used them to help me write opinions. I used them to help me do research on specific topics. That was about it. Sometimes I'd even have them write letters for me.
When you were on the Supreme Court, did you enjoy civil cases more or criminal cases more? Or did you enjoy them? Or is enjoy the right term to use?
You know, it's interesting, but I perhaps could say if I had to choose between the two, it might be criminal. In most criminal cases that we took, there would always be some constitutional issue squeezed in there. And I always loved constitutional law. And criminal cases, you know, to the public, they may think, well, a criminal lawyer is really not on the same high plane as a civil lawyer. But boy, the issues in those criminal cases sometimes are the most challenging of all. And I really enjoyed the criminal cases. Not to say that I didn't like the civil cases, but the criminal cases sometimes would really be challenging.
When you were hearing argument, if you were blindfolded, could you tell the difference between lawyers from East Tennessee and lawyers from Middle Tennessee, lawyers from West Tennessee?
You're talking about the way they argued or their accents?
The way they argued. The way they handled the case.
Not really.
Could you tell difference in their accents?
Yes. Yes, I've got one of the strongest East Tennessee accents you can imagine, and it sure is different than somebody from Memphis.
We do have 3 states of Tennessee, don't we? During your years on the bench, what were, to your mind, the significant changes in the rules?
Max, I'm sure if I thought about it, I could come up with some answers, but right now I'm just drawing a blank.
Were there any differences in judicial administration during your decade on the bench?
I can't really think of any right now. I'm embarrassed to tell you that. I know when I became Chief Justice, I spent an awful lot of time on administration. Spent a lot of time. We had some good people running the administrative office of courts. We had one when I first went on to court that wasn't as efficient as perhaps he should have been, and he was replaced in 1999 by Connie Clark, who had been a trial judge down in the 22nd Judicial District, which was down in Franklin and 5 other counties. And she resigned from her position as a trial judge and came and did a crackerjack job of managing that office. You know, they had about 75 employees in that office, and she was a wonderful manager. And of course, now she's our Chief Justice and came on the court in 2008. But there's a lot of personnel issues you have to deal with as chief. When the legislature's in session, you have to spend a lot of time dealing with legislative issues, with budgeting issues, and yet you still have to write your opinions. And so it's challenging, but as the budgetary crisis began to mount, we had to make some hard decisions, and I think the court is still having to make hard decisions about personnel and about what you can do with the money you do have and the money you don't have, what you can try to replace it with. The federal grants that we used to get are beginning to shrink. State funding has shrunk, and so you have to try to make the best you can do with what you have, and that's getting hard. For example, we talked earlier about being able to go out to the College of the Judiciary out in Reno, the State Judicial College. We used to be able to send people out almost yearly if they wanted to go and there was a course, but those days are over.
When did you become Chief Justice?
September 2005, upon the retirement of Chief Justice Frank Dorota.
How were you selected?
Interestingly, the court selects its own chief, and so the remaining members of the court thought I could do the job and elected me.
When you became Chief Justice, how much of your time did you have to spend on being the public face of the court?
Quite a bit. I think the present court may be making more public speeches than I perhaps did. You know, I see something almost in the paper daily where after I left, where Janice Holder, when she became chief, was out in the public a lot, and Connie Clark is continuing that. But I spent a lot of time giving speeches and going around the state and helping teach seminars and just being there.
Is that important?
Yes, yes. You know, we had a project that Riley Anderson, when he was chief, started in 1995, called SCALES, which stands for Supreme Court Advancing Legal Education for Students. And so when invited by trial judges around the state, we would go into those districts and we would hear cases in front of high school students, and it was really one of the best programs in the country for that. And I guess we've, as a Supreme Court, during my 10.5 years on the court, probably held court in at least, there are 95 counties in the state. We've probably held court during my 10.5 years, probably in 35 of those counties. And it gives high school students an opportunity to see real cases.
Have you thought any about what the judiciary can do, the Supreme Court and the Court of Appeals and the judges on the trial benches, to help people of the state better understand the role of the judiciary?
Well, I think occasions like Law Day every year on May the 1st offer an absolutely fabulous opportunity for judges and lawyers to speak in the schools, to speak to civic audiences and to others about what the judiciary actually does and the rule of law. There are other occasions I, for one, would love to see civics classes back in the classrooms. That's sort of gone by the wayside, and I'd like to see the judicial branch of government and the bar associations advocate for perhaps having volunteer teachers go in and teach 1 or 2 days a week. Doesn't have to be the same lawyer, the same judge, but go into the schools and teach basic civics. That's something that's just fallen by the wayside, not only in Tennessee, but around the country.
I want to switch back to one of those practical things that people wonder about. When you were going to write an opinion on a case, how do you go about constructing an opinion?
First thing I would decide is how I'm going to rule. And then after discussion with the members of the court and hearing their views, I want to draft the opinion in such a manner as to try to accommodate as much as possible the views expressed by the other judges. I don't have to put in a sentence that I know is going to make somebody upset. I need to add a sentence or two that's going to make somebody get on board that may have been wavering one way or the other. I want to draft it in a way that is going to make the least amount of change that's required to reach the decision. I don't want to answer questions that weren't advanced or don't need to be answered. And so I try to make it as pithy as I can, although sometimes my opinion's got to be pretty long. And others of the court, I wrote a dissent one time that was 28 pages long, and that's 28 pages in West, which I think may have been excessive. But I was answering a majority opinion that's about 30 pages long. So I'd write, and after I'd write one, I'd put it on the shelf and let it sit about a week or two, then pick it up and read it again. And I'd always say, why did I write that? That doesn't sound good. And so I'd go back and look at it again, but try to let it sit for a few days and let me go back and look at it fresh. And the amazing thing is today I can go back and read some opinion and say, did I write that? I don't remember saying that. I had a law clerk once, and he's now a partner in this law firm, and his office is right next to mine, named Tom Greenholz. He has a photographic memory. He can tell you every opinion that ever came out of our office and what the issues were and the name of the lawyer. I mean, it's incredible, and I don't have a memory like that.
We all wish we had memories like that. Tell us briefly about the importance of dissenting opinions.
Well, number one, it gives the dissenting justice an opportunity to vent. Number two, often the dissents of today become the majority opinions of tomorrow. And we can, as lawyers, you and I can think of any number of cases. Take Plessy against Ferguson back in the 1890s on segregation of public transportation. That dissent became the majority opinion later when Chief Justice Earl Warren wrote the majority back in 1953 in Brown versus Board of Education. So it gives an opportunity for the legal scholars to critique the opinions of the majority. So I think dissenting opinions have their place, but I don't think judges ought to dissent unless they feel fairly strongly about an issue.
What are you doing now?
Well, I'm associated in the law firm that you're with, Chambers, Bahner, and Stoffel in Chattanooga. I'm of counsel, and primarily I'm engaged in arbitration and mediation. And from time to time, some of the lawyers in the firm might ask me to do something special, like give them my thoughts about a brief they're writing and what I would suggest they ought to emphasize. But I don't go to court. I just don't think it's appropriate for me to be in a courtroom. Others may disagree with that. Certainly there have been other members of the court who've retired and gone back to court, but for me personally, I don't think I need to do that. And I go and come as I please.
Do you enjoy the arbitration and mediation?
Yes.
Find it intellectually stimulating?
I like arbitration better than mediation. Arbitration to me is easier. In mediation, you have to go in and plead with them, cry with them, beg them, laugh with them, cajole them, and I go home at night and I'm just worn out. And in arbitration, that's pretty much like being a judge, and that comes a little easier for me.
What are your hobbies?
Traveling, cooking, reading history. That's about it.
What are you reading now?
Well, I just got through reading, this is an old book, but it's still one I've read it for the second time. This is a book by a fellow named Johnson. What's his first name? He's an English writer. Johnson's his last, I can't remember first name. It's called A History of the American People. And it's a one-volume history that starts with the Portuguese exploration in the late 1400s and go through Bill Clinton's first term. It's all in one volume, about 1,000 pages, and fabulous. And I'll think of his first name in a minute.
What's the next book you want to read? Do you have one on tap?
Yeah, it's not out yet. John Meacham has got a book coming out probably this summer on Jefferson.
Are there any future lawyers in your family? Do you have any grandchildren who you think might be interested in the law?
Not at this point. My oldest grandchild is a little girl 10 years old, and my youngest is a little grandson 4 years old. So I don't think they've even given any thought to what they want to be. But none of my children wanted to be lawyers.
Looking back over your life, Mickey, what are some things in which you take most satisfaction?
Helping my wife raise 3 great children. You know, they're all married, they're all happy, they all got good homes, and I got great grandchildren. That's what I take most pride in. My relationship to my Lord and helping develop the law.
Thank you.